Good evening, everybody, and welcome to the White Collar Support Group Tuesday Night Speaker Series. Tonight, we have two special speakers. We have Anthony Bracco and Brian Sanvidge from Anchin Accounting and Consulting. And the topic tonight is going to be about early retention of financial experts in white collar cases. More about that in a minute. First, some housekeeping. This event is brought to you by the White Collar Support Group, and we meet on Monday nights and Thursday mornings every week. A few weeks ago, we had our 500th weekly meeting. You can find us on our website at prisonist.org. That's prisonist like feminist. And if you or a friend or family member, client, colleague, anybody in need wants the kind of resources we have support group meetings and all kinds of other resources for people who are being prosecuted for white collar crimes and their families. Please come to our website, prisons.org, and you'll find all kinds of resources there. And if you're directly justice impacted, you can join us on a meeting, and we'd love to have you. We have a bunch of Tuesday night speakers already lined up for the next few months. So I'm just going to mention them quickly. Next month on March 24th, we have Sam Mangle and Craig Rothfeld, and they're going to give us an inside look into the world of prison consulting. For all you white collar people, you know that in the last few years, prison consultants have become part of the white collar ecosystem, and they're going to give us an inside look into all of that. Brand new on April 14th, we have a lawyer from Nashville. His name is Alex Little, and he's done some great work for some people in our group and is gaining a national reputation from that outpost in Nashville. He's all over the country. So Alex Little is going to be with us on April 14th. On May 12th, Tom Harden is going to be with us. That's Tipper X. And he was one of the largest informants in Operation Perfect Hedge back when there were a lot of insider trading prosecutions. And his new book is Wired on Wall Street. He will be speaking to us, and he's on his national book tour. His book comes out tomorrow, but I just got notice from Amazon that my book's on the way already. So more about Tom in the weeks ahead. And then in June, on June 9th, we have PG how do I pronounce it, Brent? PG Settenfield.
Yeah, Sittenfeld. Yeah,
Settenfeld.
yeah.
And he's was a Cincinnati city council person who got prosecuted and has a tremendous story. And he's doing a lot of speaking and all over the country too. So that's all coming up in the next few months. We're super excited to have Anthony and Brian with us tonight. So I'm just going to do a little bit of reading about what tonight is about, right? Retaining financial experts early on a case significantly increases your options, strategy, and chances of successful outcomes. Early retention of experts can also reduce the cost of the engagement, allow assistance with planning, discovery, including e-discovery and data analysis, and provide early information that might drive a settlement. During this presentation, Anthony and Brian will discuss the ways in which a financial expert can assist in building a strong defense, why it's important to retain your expert early, and challenges they have faced when not being retained early. I've met Anthony through our good friend Elizabeth Kelly, who has been a previous Tuesday night speaker. And we spent a lot of time together at ABA white collar conferences. And this is, and we told them this is just like one of our main themes in our support group is making sure that people get the resources they need at the right time and learning how to advocate for yourself. And what we talked about was one of the things that does not happen often enough is that the experts and don't get brought in early enough, and they wind up being sometimes an afterthought, which is really a shame because when all the evidence and the experts are brought together early in a case, then it can help with the plea, it can help with the pre-sentence investigation, it can help with sentencing, and these days it can potentially even help with a pardon. So, very important to our group, very important to our community in general. So I'm going to hand it over to Anthony and Brian. They have a PowerPoint presentation, and then afterwards we'll open it up to questions and to that's it. So Anthony, take it away.
Thank you, Jeff. I'm just going to share my screen. And Jeff, congratulations on the 500th meeting, and thank you for having us here to present tonight. Uh, what we are going to talk about, and everyone can see. You can see. Can you see that screen now?
Yes.
You can see it. The PowerPoint. Okay, great. Perfect. We're going to focus quite a bit on the benefits of retaining a financial expert early in a matter. But, I want to just sort of start out dispelling one of the, key misconceptions, right? Which is, we often hear that, there was a delay in bringing us into a matter in an effort to save money. Perhaps there was a thought that the issue may get resolved, and why spend the money sooner than is necessary. And we're going to talk about the reasons for that. The reality is it does not save money and can often cost more money. The work still has to be done, and you have to do the same level of work if you're going to do it properly. And all delaying that retention of a financial expert, all it does is compress the time that the expert has, and often can often limit what the expert is able to do for a client. So it really does not save money waiting to bring in the expert. It often can cost more because when you're under a time crunch, you often now have very high level people having to do a lot of the work that might otherwise be delegated and supervised by someone at a high level. So it really, and the other thing is you can identify early on, when you have time to think about a matter, certain paths that you may decide, okay, we really don't need to address this issue or that issue. But when you have a tight timetable, you don't have that luxury of thinking that you just have to really attack every avenue and do the analysis looking at every possibility. Whereas if you had some time to think about it and assess, you might eliminate some of the work that you would end up having to do. So just looking at our agenda, we'll talk about how your financial experts can help shape the narrative of a case. And the earlier that they're involved, the more help that they can provide in shaping that narrative. So, the government is going to have their own story, right? And they already know sort of what argument they want to make, and you want to be able to get in early and be able to explain certain concerns that they may have. So number one is shaping the narrative. The second benefit is being able to manage the data. When we talk about, data and e-discovery, we're often not talking about, gigabytes of data. We're talking about terabytes of data, hundreds of thousands, if not, more documents. And that is a very heavy lift to deal with in a short timetable. The next one is the impact on outcomes. The financial expert can help improve the outcomes of cases, and we're going to talk about that, as well as the expert gap. When the government has their financial expert looking at information, they have a head start, and they also have significant resources. So their expert is way out in front, and bringing a financial expert in early on the defense side helps that expert close that gap and start to get on top of some of the issues and address it early on, so that we're not always playing catch up. On the next slide, we'll talk about shaping the narrative. We could define intent, right? The what, right? The transaction, what actually happened is often not in dispute. If you're talking about a financial transaction, it's very often going to be, the transaction's documented. We know that it occurred. What really is important is the why, right? Why did that transaction occur? Can there be a reasonable explanation for it versus, what the government may be assuming or incorrectly interpreting, right? So you want to get on that early because during the course of, the government looking into a situation, you may be able to settle it before criminal charges are actually filed if you can explain really what happened. But you need to have the financial expert in early to be able to do that. Also, just taking a proactive stance. It ensures that the strategy of the defense will align with the financial realities, right? You don't want to go down a path and have a narrative for your defense and then bring in a financial expert who then says, well, now I've reviewed all the documents and they don't align with the story that you may have been telling the government. Now you have to shift gears and you could potentially lose credibility. So you want to know early on, do the documents support the story that you want to tell? And then ultimately identify alternatives. You could look at alternative loss models. We all know, the government's going to come in and they're going to come in with the highest number they possibly can in terms of losses. And there's a lot of different ways to look at financial matters and economic analysis. And we could come up with alternative models and alternative theories in terms of what the losses actually were, which are going to go a long way in terms of what what the potential charges may be, and ultimately what sentencing could be.
One of the important things there on the, identifying those alternative, strategies that are going in, how can we passionately be able to help on the defense side to make sure that we're not getting dug in on a particular defense strategy when we like to say we've got some real inconvenient facts here when you start digging in that are problematic to that defense strategy as to what we ultimately have. So early on looking at this data really helps on the defense side to be able to make sure that the defense strategy has all of that information as opposed to we're a week out from trial or a settlement and we're talking about inconvenient facts that just came out that we weren't prepared for. And how do we deal with them? It's what's the best spin that can ultimately be put on that? Is there an explanation? Or let's further go down to that one really incriminating email and what is there when you look at, as Anthony had mentioned, we're doing one right now. There's 2 terabytes of information. We were amazed when counsel said that's how much information they were sending us, that could be possible. But it's just the amount of emails and everything else that's done in a, post-COVID environment. Everything's electronic. So what is in there that all brings that full picture of what happened there that can really be helpful on the defense side?
Yeah. And looking at how do we enhance the early evidence, right? We can identify accounting or valuation discrepancies that are critical to your strategy. We've said it a couple of times. It's important to know what problems there are or what landmines there are within the financial information. You want to reduce the blind spots, prevent surprises. You don't want to bring in the financial expert late and find out later on that, sure, a lot of what the government's been saying, is actually, true, or, or the records just don't support, what we want to explain to the government. It also improves efficiency and can lower the cost, as I mentioned. You can really lower the cost because you have a lot more options in terms of how you approach the analysis, rather than being, under this tight timetable where now you just have to go in. Basically, you go all in with all the resources you have to, turn over, every rock. where when you have some time, you can really, strategize in terms of the most efficient way to approach something. Uh, and ultimately increases the likelihood of a more favorable outcome. I'm going to turn it over to Brian to talk about data. We know that we deal with huge volumes of data, and so Brian will address some of the issues that come up.
Thank you, Anthony. When we're talking about, working on a more favorable outcome, what is the best outcome for the current situation that we're facing? We understand everybody, there's limited resources on all sides of it. Unfortunately, the government really doesn't have that limit. After a career in government, for me, it was just prioritizing what I was going to have my analysts and investigators be able to do. On the defense side, there is limits to that. So how do you do that most efficiently, get enough information so that helps to ultimately model and come up with what the best defense strategy is going to be for what ultimately happened here, and whether that's something that is going to be used during the investigative stage, during, post grand jury, during a settlement stage, or during the trial. And then at the end, we'll talk about, post trial after a set, either conviction or a settlement, and where a lot of this information can really come in that can be helpful in trying to mitigate what that ultimate exposure can be that's out there. So on the data management and discovery, the analytic tools right now, so we know there's a lot of data. I talked about, the case where Anthony and I are on right now that has a couple terabytes of information, but data analytics, we can drill down on that. And what we want to be able to do is to work closely, as a consulting expert with the defense team to come up with what is all the information that is there. Sometimes that may be involved, depending on if it's, company related or not, where we're running in, a parallel investigation with the governments to find out what the government's going to find out. How can we ultimately defend against that? What information do they have or will they ultimately have access to? But there are software out there now that we're using on the emails to be able to drill down and then to be able to get it and put it in a very user friendly way for clients, defense counsel to be able to go through it and to see, what information is in there that is helpful. Also to point out what information is problematic, what's going to come out, so it's not a surprise. So we ultimately be able to have that information. We've all been involved where, it's 2 weeks out before we need this and there's a full data dump. And how do you deal with that? So if we have the ability to get the information early and to start to do it, it's that much more efficient, earlier, Anthony was talking about the cost size of it, and because cost obviously is always a concern for everyone involved, as it should be. But what we can do is when you're involved early, you can start to set the scope and how can we help with what the narrative is, explaining what happened, what ultimately is out there that we can drill down on those documents and on the digital side. That's either going to be helpful, it's going to be problematic for us. So at least we know it. So when counsel's building that strategy, they know of all those issues there. It's really going to drive on the efficiency side. Being able to get the access to the information earlier definitely cuts down on the cost side, because then you can start to scope out. Here's what's important. Let's look at either these type of transactions or something else, and you can start to do it. And then looking at the information to be able to drive that analysis and get the feedback back, from the advocates, from your counsel as to what is going to be there that's ultimately helpful to be able to do that. And then to continue to dig down and what we can do that ultimately to do further analysis, either to make sure that we know of all the minefields that are out there, or if there's information that's out there that's helpful to our position and what that is. And then ultimately, so counsel can use that and weave that in to when they decide is the most appropriate time for that. Next slide, Anthony. you know, and then just understanding the sheer size of it. So the data management and the discovery. First of all, what access to records do you have before you get them from the government? What records are out there? What's available to ultimately to be able to look at? And then organizing that data in a manner that is useful for everybody who's working on this matter so that they know where to be able to get it, set it up where it's there. And then if it's ultimately going to be set up and it's going to be used either for a presentation or used in trial, to make sure that we're linking that information together. So when you need something, you can bring it right up and it links you right back to that exact document that is helpful to what we have, and being able to pull all of that information together. It also helps us to identify missing data. There are so many different types of financial systems that are out there, especially on the accounting side, where we run into when you start to pull that data together, whether it's the government doing it after a search warrant, whether we're trying to pull it together, sometimes that migration of that data is inconsistent. You want to make sure you have enough time where you can spend so you can drill down if there's something in there. And then working with, counsel to make sure that we're looking for the right thing. What is helpful to that? So we're not going down that rabbit hole that's just not going to be helpful to frame what the position or what that argument ultimately is going to be that is out there. Identifying those key documents early on that are going to be helpful, whether they're going to be used in a settlement conference or they're going to be used, during a trial. What are those documents that are out there? Being able to pinpoint the critical information that is there, whether that's in a ledger, whether it's in the financial records, whether it's in emails or correspondences that were back and forth, to make sure we have that. And then also, if we're looking at it and there are our own internal records, how do we preserve that to make sure that they're available in case at some point the client doesn't have access to those records, so to be able to preserve those till we have them. And then clarifying the different, financial, complexities that different systems will have, and bringing the expert in to be able to look at it as to what does that mean? Where does that flow through the financial statements or to a tax return? Because that can really drive what the ultimate amounts of some of this was. How was that ultimately treated? What was the business doing with that? And, looking for that information and then making sure there's no errors there, or if there were errors, that's brought to everybody's attention.
Yeah, and we've had multiple situations when we're talking about data where we're looking at a business's accounting records, and they did change accounting systems during the period that's being looked at. So they had two different accounting systems over the years, and at times when you migrate that data, it does not all come over perfectly, and the government will look to make a big deal about that when there may be a perfectly reasonable explanation. If the data doesn't come over consistently, it doesn't, it doesn't reconcile to what was to the old system, they will make a big deal out of that. And you need someone in early on to sort of reconcile those differences and be able to explain that this is, there's a perfectly logical explanation for this. It's not so, it's not something to be concerned about. So, we have seen that happen more than once.
And Anthony, to that point, when you're saying, it's coming across, it's easy for the government to say, well, it's convenient that now there's this problem, but we can show what ultimately drove that problem. There was one system, the system was replaced, and here's what happened. We see that in data migration all the time as to where they are, but being able to show that and show exactly what happened, why it happened, and where it was. It's not that someone went in and did something to it. Data gets corrupted as to, what it's there, and being able to pull it all across. And the idea is ultimately when we're doing this is how do we take this information and enable counsel to use it as a stronger negotiations point. Here's all of the information based on, some assumptions that the government either has it or is going to have it. So early on, that information to drive if there ultimately is going to be a conversation for some sort of negotiation for whatever the appropriate settlement or the best deal is going to be on this. What is out there. So the early scoping just prevents any surprises. We know ultimately what the government will have and what they may have on that, and to be able to do it. And then going through that information to make sure that we can put all that information together in a tight format so it's organized, so it's useful for when counsel is needs it and needs to go through it when they're going to do it all. What we're ultimately trying to do is reduce what they refer to, what is that investigation tax? What does this ultimately cost? But let's do it as efficiently as possible to make sure that the information that can be gathered can be used for someone's, for the benefit of it as to where it is, and it's readily available for everybody. And then taking that information and then, Anthony, to you on the trial readiness, and how do we
Yeah.
use that information now at trial?
Right. So ultimately, you take all this information and you want to be able to get ready for trial, and you want to have time to do that. The more that you can put together in terms of analysis and rebuttals to the arguments that have been made, now you sort of put the other side back on their heels a little bit, because now they have to be able to address all of your rebuttal points, all of the counter arguments that you've come up with. So you need the time to be able to put together those strong arguments and sort of put them back where they're sort of now playing catch up with you. And they have to figure out, okay, wait a minute, does the defense actually have a point here? And now they have to dig in and figure that out. It also helps prepare witnesses by having the information early on and being able to document it and do the analysis and show the witnesses what the documents are showing. It may help, it will help refresh their recollections. They may have, they may recall something, differently than what the records actually show. And you don't want the witnesses seeing your expert's analysis, days before they have to testify. You want them to have time to see it and understand it and make sure that everyone is consistent with what they're saying. And making sure the witnesses are prepared, that they understand the information. A lot of times, witnesses, they may not have been in the details as much as your financial expert is going to be. And so, they're trying to do it from their recollection or, as they know it, but you want them to have that deeper understanding so that they're more comfortable speaking to it when they have to testify. And then there's other benefits internally, to an organization when you go through this process, which is you identify issues. What caused the problems, the financial issues that we're having? Were there lapses in our internal controls, or were we just lacking the internal controls? And let's strengthen those controls, get a better system in place. And that, Brian can speak to this. I think that goes a long way when you're speaking with the government, that, we've identified this problem and we're addressing it.
And to that, it's ultimately on the internal control side of it is if the government's taking the position that the total dollar amount is X, because here's what that all adds up to. Potentially it's not X, it's X minus a significant number, because all of those costs should not be put towards one person as to what they were. What are those dollar amounts? Some of those may have been very legitimate transactions that have an explanation as to what they are. It's very easy when you're looking at it to take a position that anything that was in this category, because we know that category was problematic, ultimately goes towards the government's position that, those funds were taken or were allocated or misappropriated during the course of it. But to be able to show it on the internal control side, especially if you were dealing with the entity side of it, to be able to show that now there's these internal controls have been put in place to make sure that this can't happen again and how we're going to ultimately be able to deal with it. When on that, which goes obviously a long way in dealing with something if we can ultimately get to what would be the best settlement, potentially even a civil settlement as opposed to a criminal settlement on it, with all of the information that is there.
And
Next
when
slide.
when a company is dealing with this, it also helps stabilize the company as well, right? Because when you start addressing these issues, identifying the problems and putting, remediation in place, it helps with a board of directors, it helps with lenders and other stakeholders that they understand that you've identified the issue and you're addressing it. So it also helps stabilize a company that may be, dealing with a lot of different issues.
Then when we start to look at, what is this driving? What is, how do we take this information that we have and have it become a significant impact on what the outcomes and what the outcomes we're looking for and what counsel's narrative is for, and advocating for the defense on this, right from, pre-indictment, that investigative stage through any type of plea negotiations or trial, and then at sentencing. All of these are important pieces to make sure that that data is being used to its most beneficial way. So starting to look at it to clarify complex financial activities before prosecutors, regulators are misinterpreting them. You can't expect the government to be a financial expert when they're looking at how something was treated in a financial statement. How was something booked? How was it treated for tax reasons? And what that's there. So the financial expert can really help you with that information because often they can be very complex scenarios, but it doesn't mean that they're illegal, that a crime was committed because of the way someone did something. It may be on the advice as to what, that was a proper treatment for tax reasons or for, dealing with that for tax liability at a future time, and then starting to identify, the beginnings when you're pulling this data together, what are the explanations? What are the reasons for these transactions, that took place? If they look suspicious, why do they look suspicious? Is there an answer to that? Is there an explanation? Or if there's not and we know about it, it's a problem that we get to deal with up front. We know that when this information comes up, it's going to be a problem. We also get to look at it and correct flawed information. It's not unusual at all that, on the government side, they take the information and they start to jump to conclusions that everything in a particular category was, an element of a crime, or everything in a particular category goes to what the loss was to the victim. That's not the case at all. Let's look at it and drill down on each one of these as to what it is. So you're able to, during those, whether it's during, a pre-indictment, during a plea, is to being able to talk through with the government as to what those are, why they were, and why they're wrong with some of the assumptions that they're taking on that, and here's what it is. Being able to supply the organization and the team ultimately with, the credible information that they need to be able to do it. As we're going through it. We want to be able to, whatever the loss amount is, let's make sure that we recalculate it and it's accurate as to where it is. Identifying all the allowable offsets. If there was anything there that there was a legitimate business value or reason that was there. Clarifying the client's actual involvement in it and separating out their conduct from the conduct of others that were, potentially involved. Demonstrate whether there was, a lack of intent, knowledge. What was the ultimate benefit that someone had from this action that they're being accused of? being able to cut off all of the enhancements and the ties and thresholds to other victims, on a very sophisticated means. We want to be able to show what it was and, excuse me, what it ultimately it happened there. Use the data that we have to drive these conversations as to where we are, what are the facts, and what are the facts that ultimately support our position that we have, and just being able to provide all of that information. Next slide, Anthony.
Yeah, sure. And so, yeah, so some of these comments, relating to sentencing are similar, in terms of recalculating alleged losses and differentiating the actual losses. You know, a great example of this and is a case that I had worked on where an individual was accused of it was basically defrauding a bunch of investors. Um, but what the individual actually did is they were taking investor funds and they actually did invest it in distressed real estate. And ultimately, what happened was there were some issues there, and we're not, no one was denying that there were some issues with how investor funds were used, but overall, the individual acquired assets. They acquired this distressed real estate, and the government seized all of these assets. It was around 2007, 2008, and the receiver that or the assets were, that was responsible for holding these assets basically held them right through the financial crisis and then sold these properties at pennies on the dollar. And we were able to show in terms of working, and negotiating this, that when the government seized the property, they had value. They had a lot more value than what it was ultimately sold at. So that went a long way towards this, individual sentence. But again, great example of needing to bring in experts early. I mean, to do that, it involved dozens of properties, half a dozen different entities of tracing the money. Those dozens of properties all had to be appraised as of a date several years earlier. The professionals it takes the professionals time to do that. And if you retain your financial experts too late, they don't have the luxury of the time to go through that exercise. In this case, it really, paid off significantly.
We did one, Anthony, you and I, that involved, publicly traded, stocks that were involved. And the position there was that structured, was the theft, and was the manipulation of the financial records to the, detriment of the stock price. And at the end of the day, the stock price went up. So at sentencing, my testimony there was surrounding what was the real damages, what was the dollar amount as we sat there at the end of the day. And at that point, the judge asked the government, well, what happened when you liquidated the stocks that you had bought during this time on the transactions? And they said, we're still holding on to them. We could show where that stock went up in value. So it negated any of the theft amount that was there. So it really drove to the departure on the sentencing guidelines. We went in, the government was asking the day of sentencing for 9 years. After showing where we were, we got out with a year and a day. So it was a tremendous win for everybody. The year and a day, we got the benefit for the good behavior because we're over a year, and the way, being able to show to the judge, ultimately, here's the actual dollar amount that we were there. And we get talking about it, and counsel says, I wish we had that information earlier. That could have potentially drove a settlement, early on, that this was not the dollar amount that everybody thought it was because of where we were.
Yeah. Yeah. I mentioned earlier, narrowing the expert gap, and there is always going to be this gap where the government has a head start, and that head start could be several months. And what you need to do is get your financial expert in to start leveling the playing field. Your expert's going to be playing catch up, but if they're brought in early enough, they can catch up. And so, but you have to move quickly to be able to do that. And when you have your experts in place early, then you're sort of running a parallel analysis, not relying on the prosecution's framing of a particular issue, but you're coming up with your own story to tell. And that goes, that is a tremendous benefit. And I'll give you an example, of the expert gap. And, you know, this was not a white collar matter, but it is a great example. It was a civil dispute where we were dealing with hundreds of millions of dollars across over 100 different entities, money moving across all of these different companies. Um, it was hundreds of thousands of documents. Our team worked on it for 18 months. The opposing expert, who I knew, very qualified individual, our adversary brought him in 4 months before the hearing, where we had a 14-month head start. There was just nothing that he could do to catch up and to narrow that gap. So, that's a good example and a very dramatic example of where, we were just miles ahead of that expert. And then at the end of the day, our client, ended up getting everything that she was fighting for, because the other expert just didn't have adequate time to prepare, strong defenses. Right?
So we're talking about, narrowing that expert gap, so one of the things where we think we can really always be very helpful and we want to, before we get into some Q&A here, is to, how can we provide advice early on, uh, to be able to help counsel to advocate on it. So often what we'll do is we'll set these up where it's a Covell agreement where we're brought in as a consulting expert. It's, set up as a Covell, so there's attorney-client privilege where counsel's calling us and asking us to do things, early on it where we're looking at data for them. But to set it up under a Covell extends that attorney-client privilege for it. It adds that level of comfort for everybody that's involved. And then there's not a concern that anything we're doing early on, even if our work ends early on, that can ever be used by the government against somebody. And then setting it up where we're often the shadow consultant. We're in there where we're brought in to work with counsel to say, okay, here's where the government is going to go from an investigative. Let's look at it. What's there? What exposure's out there that's going to be problematic? What is out there that's going to be helpful to ultimately our position? And being able to create that strategic information to be able to pivot and be able to deal with whatever those, we refer to them, those minefields that are out there. And what are the, those positive bits of information, as small as they may be, that help counsel with that story that they're trying to tell here on it. Having the privilege there, extending out to all the experts on it is really helpful. And then, the whole goal here is being able, how do we mitigate the risk, and by bringing the expert in early. And a lot of times we're brought in and it's questions up front, and then there's not a need for work for an extended period of time. And then there's, more week. And then a lot of times it ultimately ends up settling. So back to that, that cost part, you're brought in early, you're able to give some information, and then the case, and that information's helpful in ultimately trying to drive, what is the settlement? What is the best settlement that is out there for everybody that we have? What I'd like to do now is kind of open it up for, some, question and answers. And then here, this is our contact information. So any questions that don't come up tonight at any point, don't hesitate to, send either Anthony or myself an email or pick up the phone and call us if you want to run a scenario by us. Prior to being in the forensic consulting space, I did 25 years in government. So, I was on the other side in doing these. So if we can be helpful at all and you just want to run a scenario by us or have a question, it's not unusual. Please don't ever hesitate to call. But Jeff, do we have any questions in the chat, or let's open it up and how can we be helpful?
Yeah, if anyone would like to ask Anthony and Brian a question, please put your name in chat and I will call on you. And I'm actually going to ask the first question. Um, in our conversations in our support group, and this has been going on for years, we're sitting trying to educate ourselves and advocate for ourselves. But most of us, when we entered the system, wherever the point of entry is, we're in trauma. We've just been arrested, or there's been some other kind of event, and we're referred to a lawyer, and for a lot of usually emotional reasons, we're no longer good business people, no matter how sophisticated we are, then we're not able to protect ourselves. And it seems like we're not asking the right questions, or we're not demanding that the lawyer lay out things in kind of in a business-like way. So where you would think that you'd be able to set a budget, okay, this is how much it's going to be for experts, this is how much it's going to be for this is how much it's going to be for that. Often it becomes a black box, and we don't really know what our lawyers are doing.
Mm.
And our fear is that what they're doing is they're not bringing in the experts. And so, how often is it do you find that the lawyers and the clients are are fighting with one another as to money, as to when things should be brought in? How involved do you get in the actual presentation of this information to the clients themselves, so that clients can actually start to wrap their heads around all of this? And you kind of get where I'm coming from. It's
Yeah.
like you guys have important role in all of this, but from my perspective, or from our group's perspective, not not brought in often enough, early enough.
Yeah, and when you're in that situation, you really want to insist that counsel even introduce you to a couple of different experts to explain how they would approach it, right? You want someone that you're going to be comfortable with, but they should also be able to explain what their approach is going to be. I would not expect that they're going to be able to tell you what something is going to cost from start to finish. But the way we like to approach it, Brian and I, is, let's look at this in phases, right? So we're going to start out looking at this piece, and there's this volume of documents. So we can generally estimate what that piece will be. We can't tell you what it will be from start to finish, but you want an expert who's going to communicate with all the parties. Jeff, to your point, yeah, sometimes there's conflict with the client and the attorney, right? That happens. We want we want the client to be involved, to know what's happening, to know what we're doing, to understand the value in what we're doing and the reason why we're doing the work that we are doing. Why is it necessary? I think that's all very important. And at the same time, we want the attorneys to help us, explain that to the client that it's important. I had a case where, not I did not have a case actually. I actually walked away from it because in that instance the client was driving it so much, and counsel was sitting back, to where the client met with me multiple times and was trying to explain to me how the financial analysis had to be done. And I repeatedly explained why that was not going to help defend the arguments that the government was making, and here's how it really should be done for a solid, credible defense. And ultimately, the client said, "Well, I need to work with someone who's going to do what I tell them." I walked away, and a year later, she was sentenced to 2 years.
Mm.
Yeah.
Jeff, you asked that question about being brought in and you go through someone's just been charged. So you got a first deal and that's, counsel's involved. You've been charged. You have that emotion surrounding that. And now you're dealing with counsel as to what are the next several things that have to take place
Mhm.
right away. And it's not hiring the consultants. It's not bringing the expert in at that point. But it's not too far after that.
Mhm.
After you've gone through the initial procedure part of it, and counsel's then starting to come up with, okay, what is the defense strategy of this is going to be? What is the real total dollar amount here? Actually, what is that amount? And having those conversations, and it goes both ways. We'll be brought in, so defense counsels that we work with closely all the time. A lot of times they're bringing us in right at the beginning and say, let me run a scenario by you. Here's what we have and what's there. And then, often we do want Jeff to, at some point very early on, is let's meet with the client. I want to hear from the client exactly what was there. So how can we help? How can we be helpful to that? We don't want the scenario that Anthony had just talked about where they have a spin they want to be able to put on it because they feel that it's going to work. When we know that that's not, we can't as an expert be able to testify to that or that's not the way it works, but to that. But ultimately to have those conversations and to have that, involvement early on with the client as to how we can be helpful. And we know our role as to where it is and when we're needed. But it's some of the best cases is you're brought in early, you have those conversations, you may be asked to do something. And part of it is just to get ultimately the client comfortable with the experts. And then there's a period of time where there's little or no work for the experts, as the rest of the, criminal procedure components are going on.
Thank you. Let's see who has some questions. Let's go to Greg first. Go ahead, Greg.
Thanks, Jeff, and thanks for the presentation, guys. I very informative and interesting. My question is really simple. It's how often are you brought in pre-indictment, and is that uncommon?
It's not uncommon
Not
at all.
uncommon.
No. Yeah. So what happens is someone knows there's either an investigation going on, excuse me, that the government is doing something and or there's a whistleblower and the client knows there's going to be a problem. That's not unusual for us to be brought in. The amount of times that that happens, in the grand scheme of things is less than you're brought in the middle of when, documents are starting to ultimately come in as to what's there. But, if we have the luxury where you can be brought in where the client and counsel knows that with this fact pattern, we believe there is going to be an indictment. There is going to be a presentation of this information, and then we get involved with running a parallel investigation right then. Let's see exactly what's there. What ultimately can we find out? Because that information may be able to drive some sort of settlement. And we did have a case in the Southern District of Florida where that's exactly where, the grand jury had started and we were able to, through our parallel investigation, be able to demonstrate and counsel was able to convince the federal prosecutor that there was, that here's what everything happened. Here's the dollar amounts and here's the reasons why. And there was a settlement pre-indictment.
Okay, thank you.
Thank you. Elizabeth, you have a question.
You're on mute.
You're on mute.
After 6 years of Zoom, I'm still having difficulty unmuting. In any event, your presentation and certainly your slides were superb. The slide that jumped out the most to me was the one that said, it's not the what, it's the why. And in my representation of clients, I'm all about the why. And it is usually the why is because of some underlying mental health issue, whether it's autism or dementia or bipolar disorder or some type of addiction. Given that, how do you work with the mental health expert or experts That is to say, do you provide your data in a particular way? Do you confer with the expert? Would you prefer that you not know about the probable mental health issue in advance of your examination of the documents? How does this all work?
Yeah, so to that, when that scenario arises, we do want to work with the mental health professional to understand, that's an expertise that we don't have. So it's, what happened and what's ultimately causing this, that whole why part that you had just mentioned. And it's taking that information and being able to work with them as to, no, Brian, you don't understand. Here's why this would have happened, or here's, to get that. And then when we're looking at it, and then to be able to present it to that, I think that becomes a stronger team for the client. You have your mental health expert, you have your financial, your investigative expert, and coming together. Here's the story, here's what the facts are, and then on the mental health side, here's the reasons why that this ultimately happened. But I think it adds and it gives those resources ultimately to counsel, bringing those pieces together and bringing them together early on as to how can counsel advocate for the client with both pieces of that information, that's there. You don't want to look at just the financial information, the investigative information in the abstract without knowing the why.
Yeah, I think also, Elizabeth, if we it could be helpful if we know when maybe there were certain traumatic events or a period of time when an individual was not doing well, and then look at a timeline of transactions that may be problematic. And can we tie that to specific events? Maybe we can, maybe we can't, but knowing that could be helpful and sort of creating that timeline and seeing if if certain yeah if the what lines up with the why.
Great, thank you.
Thanks, Elizabeth. Nancy, you have a question.
My stuff is kind of from in the past. My stuff is all done and over with, but I was told I have to pay restitution, for example, of $4.3 million. That was on mine. My I was told to do that. My husband was told to do that, and three other people were told to pay $4.3 million for restitution. On the IRS forms, because they contacted me and say, you have to pay taxes now on $4.3 million because that's what you got. It was a federal thing. They said, you got $4.3 million. Since it was you and your husband, we're only going to charge you half of that for income taxes. Since there were five of us, why didn't they split it between five of us and do it? Is there a recourse on it? I know I can't go backwards and fight it, but it might be something for somebody else to fight in the future.
So you do have to kind of bifurcate. It's two separate issues, and that has to be done because it's really important because you're bringing up the tax side of it as to, so the government's looking at it kind of joint and severally. Hey, we got this 4 point, whatever $1 million. We want to get that back from whoever we can. The faster we get it back, we're done with it. Unfortunately, the IRS looks at it and says, Nancy, it's you and your husband, you're tagged with half of that when there's three other individuals that are out there. So you have to be able to deal with that. And we have seen where we've been brought in as to how this is going to be broken up because there is a tax, to your point, a tax liability, from this as to what that is. But that has to be done up for, at sentencing time when you're breaking it out, and everybody's going to take out that position of the joint and several on collecting the money. But what is the ultimate tax liability? And on that, on the sentencing side of it, our position would be, here's ultimately what Nancy got. She didn't get the $4.5 million. She got this piece of it. And we agree that there is a tax, ramification for that piece of it, but it's not for the whole part. And separating it out that, on the restitution side, there is someone that's out that $4.5 million, and how do they collect it? They don't care how they get there. They just want to be able to get it, from all sources.
Well, the 4.3, say the $4 million
Yep.
was split between the five of us. So there's five of us supposed to be paying that back, which is fine. My husband died, so he's out of the picture. He's done. But there's still five. But the IRS part, they said you're responsible for that. And so there's three of us, there's four of us paying taxes on that $4 million, 4 point whatever it is $1 million. Isn't that an overtax by the IRS?
Yeah. It shouldn't be a windfall for them.
Yeah.
Should be, like they're ever going to get it, but
Yeah. Yeah.
so that's kind of that's
so,
the tax IRS that they try to get rid
so
of.
Nancy, let's follow up, and I'll get you an answer to that on our tax side. Let me reach out to one of our tax advocates that we have at the firm to see, is there on the tax side of that, is there something that can be done? Happy to run that down and share that information. You'll have our contact information. Shoot us an email, and we can run that down through, one of our tax counsels in the firm and get you an answer to that. To Anthony's point, I think, the government, it shouldn't be if all five parties had the ability to pay, the government shouldn't be getting tax on what ultimately now becomes $20 million because you got five times the four.
Right.
Yeah.
Right.
Yeah. And
That's a question for one of Anthony and I's partners, and we can get an answer for that for you.
But
they're always going to take the most aggressive position.
Right.
And I had a situation where there was a corporation that was accused of not reporting the proper amount of income for certain executives, and so you had the IRS going after the corporation with taxes they should have withheld, and then going after the individuals for the taxes on that income.
Right.
And we were working on behalf of the corporation, saying, well, you've got to wait until this whole thing shakes out with the individuals because you may collect it. And the IRS says, we don't care. And so that was a battle that, is still ongoing.
Well, I just bring this up in case somebody in the future or who's going through this right now and has a restitution with the government has to deal with this. They might say, time out, I didn't get that money. And I can prove I didn't get all that money. So I don't need to pay taxes on all that. So that was my just trying to cover somebody else's patootie.
Yeah.
Thank you, Nancy.
Thank you so much.
Is there anyone else who has any other questions? We have a couple more minutes. Anyone? All right, I'm just going to ask one last question. It feels to me, or at least in my experience, that the size of the law firm and the specific experience of the law firm can dictate strategy sometimes. And so let's just take let's say a healthcare fraud case where 20 doctors, 7 years, millions of transactions accused of upcoding, bundling, all kinds of things. And the government comes in and they've had a couple of whistleblowers. And now what they've taken is a slice and they've extrapolated from that slice. But the principals know or they believe that that's not representative of the way that the businesses have been run over the last 7 years. The government just happened to get in their slice, got lucky. So it doesn't have to be a healthcare, but how do you guide the lawyers by showing them what's possible in terms of presenting the evidence differently to be able to make a better presentation?
So the example I gave earlier, where I was talking about the Southern District of Florida, that was a healthcare case and also involved a law firm that were both targets of that investigation and the grand jury proceedings that were out there. And the principals involved and counsel knew that, hey, if you look at it to your point with this one sliver, it really looks bad. If you look at this over the totality of what it is nowhere near as bad as what it is. We acknowledge right up front there are some problems, but it is not. And if you can't just extrapolate out. Now that we had the healthcare and counsel, and it was a joint defense. So there were resources there for us to be able to look at all of the transactions and say, you know what it is? Yes, we agree that there were some problems, and counsel was having a working relation with the prosecutor saying, we're trying to get to the bottom of all of this. And at the end of the day, it was a civil, and the grand jury had already started. The subpoenas were out there, and we ultimately ended up with a civil settlement. And we acknowledged that there were problems, but it was nowhere near from what you try to extrapolate it out, because ultimately there was a whistleblower, and the whistleblower knew that there were some problems. But ultimately, you had some fine professionals who were doing very good legal and medical work. Someone had narrower judgment. A whistleblower knew it, but you couldn't extrapolate that out to both of those firms as to what it was. It wasn't fair to be able to do it. Luckily, they had the resources where we were able to drill down and say, let's look at this in total. And we said to the government, we'll share it. Counsel said to the government, we'll share every bit of what Sanvidge is doing with you as to where it is. And then let's deal with what the real amount of it is at the end of the day.
Yeah, I mean, if you're, yeah, I think you could also look to attack their sampling methodology, and then which gets a little technical and may not be easy for people to understand. But then you could also, in Brian's example, they had the resources to then look at the entire population. But even if, maybe the approach is, if you don't have the resources, maybe it's, let's just grab another large sample and show that it's not, that this extrapolation doesn't work across the entire population. There are ways you can look at, population of data and then explain why, why there's going to be differences, and why you cannot extrapolate it and get a reliable result.
That's brilliant. Anthony, Brian, thank you so much for your generosity and for all your information this evening. This is going to be available on our YouTube channel and on our website. We'll get it to you quickly, and we'll spread it out to all of our support group members in our greater community. Thank you, Anthony and Brian. Just one more time, tell us how people can get in touch with you.
We'll share the slide deck with you. The last slide has all of our contact information there. All else fails, you can always find us on LinkedIn or at the firm, but you'll have it on our slide deck, and it's got all our contact. And please, Anthony and I take phone calls all the time. Don't hesitate to pick up the phone and run a scenario by us where we can be helpful. Nancy, please shoot me that email. I'll get you an answer to that. Not sure if it's going to be helpful to you, but we'll get you an answer to that. Bring in some of our tax counsels at the firm and run that down. So just, with that, please give Anthony or myself a call, just to run a scenario by a strategy that you're thinking of doing. Can we be helpful on it? Happy to have those conversations.
Thank you so much, Anthony, Bracco, Brian Sanvidge. Thank you for being our guest speakers tonight. White Collar Support Group meeting next Monday night at 7 p.m. Eastern, 4 p.m. Pacific. Blessings to everyone. Have a wonderful evening, and we'll see you next time.
Thank you.
Thank you.
Good night. Thank you.
Good night.